Can you be charged for not reporting a fire in New Jersey? In New Jersey, the danger of fire is not rare or hypothetical. In one recent year, more than 25,000 fires were recorded statewide, meaning a new incident every 20 minutes. With neighborhoods bordering wooded areas and human activity contributing to an average of 1,500 wildfires annually, the risks are constant. This environment makes understanding the obligations and potential consequences of failing to report a dangerous fire critically important. New Jersey law includes specific provisions addressing inaction during a fire emergency. Under NJSA 2C, 17(1)(c), failing to control or report a dangerous fire can lead to a fourth-degree criminal charge. This is not a minor matter, as a conviction under this statute can alter a person's life in lasting ways. New Jersey statutes create a clear framework for liability. This law applies when a person knows that a fire is endangering life or property and either fails to take reasonable measures to put it out or fails to promptly give a fire alarm. However, the statute also recognizes personal safety. No one is required to act if doing so would create a substantial risk to themselves. Instead, reasonable action might simply mean promptly calling 911. This charge is part of the broader arson statute, which includes aggravated arson and arson for hire. A conviction for failing to control or report a dangerous fire is classified as a fourth-degree crime. It is an indictable offense that can carry up to 18 months in prison, fines up to $10,000, and restitution costs. Perhaps most serious, the record of conviction cannot be expunged, permanently impacting employment opportunities, housing, and professional licensing. Can you actually be charged for not reporting a fire in New Jersey? The answer is yes. A person can be charged if the prosecution proves three elements beyond a reasonable doubt. First, the individual must have known a fire was endangering life or property. Second, they must have failed to act reasonably, either by not attempting to control the fire when safe or by not alerting authorities. Third, there must have been a legal duty, official, contractual, or arising from control over the property or origin of the fire. If any one of these elements is missing, the charge should not result in a conviction. The process behind these charges involves detailed examination of the defendant's knowledge and actions. Prosecutors often rely on circumstantial evidence to show awareness of danger, such as behavior or statements made at the scene. What counts as reasonable action depends on the situation and the person's abilities and resources. For example, someone with physical limitations may not be expected to handle a fire extinguisher but would still need to make a prompt emergency call. A person walking past a fire on property they do not control generally has no legal duty to intervene. The definition of a legal duty is also central to this process. Official duties might apply to firefighters or public safety employees. Contractual duties could involve building managers or maintenance staff with responsibilities for fire safety. Other legal duties might arise from civil premises liability laws, holding property owners responsible for hazardous conditions on their land. Furthermore, responsibility applies if the fire started lawfully by the person, was started with their permission, or occurred on property under their custody. For those charged under this statute, building a defense often means dissecting these elements. A lawyer may argue there was no knowledge of the fire, that action would have posed a substantial risk, or that no legal duty existed. An attorney could challenge witness credibility, question investigative procedures, or highlight ambiguities in the statute's application. A law firm experienced in arson-related cases can navigate these complex issues, providing guidance and strategy to protect a person's future. If you are facing such a charge, you should not assume it is minor or that leniency is guaranteed. Penalties can include incarceration, heavy fines, restitution orders, and a permanent felony record with lasting consequences. These realities highlight the importance of understanding the law and taking steps to defend your rights. For help navigating this serious situation, reach out to Lustberg Law Offices, LLC at 201-880-5311 or visit them at 1 University Plaza Drive number 212, Hackensack, New Jersey, 07601, United States, to get the guidance you need today.